Hello friends, Namaskaram. Myself is Dr. Jinesh Soni. In today's class, I will discuss an important judgment. In that case, a vigilance case has been initiated against the accused. Finally, he faced the trial and got acquitted from the concerned court. In the meanwhile, the order of termination has been passed. The factum of acquittal has been conveyed to the concerned department, but despite of that, the review petition has been rejected. Finally, the accused has moved before CAT and the remedy has been inclined to him. So first of all, we have to study the brief of the case. Then we have to see the legal point, and finally we have to see the observation of CAT. So if we are having the same problem, means we are having a criminal case or we are having a vigilance case, and the order of termination is passed without hearing us, in that scenario, what we can do is basically the moot question of present discuss. As we know that if a criminal case is pending against the accused, the departmental action could be initiated, but if the facts of criminal case are similar to departmental actions fact, in that scenario, the departmental action could not be initiated till pendency of case under PC Act or under criminal law. The proceedings are required to be kept in the abeyance. The view is supported and sustained by multiple high courts. So whenever we are having a case under criminal law, we may conclude that the departmental action could be initiated, but on similar fact, it could not be initiated. The proceedings are required to be kept in abeyance till disposal of case under criminal law or under the PC Act. In that case, which I will discuss, judgment title is Amanpal Singh versus General Administration of Jammu Kashmir. Judgment date is 25th of August 2025. It is pronounced by CAT. The accused claimed himself to be the resident of Jammu Kashmir. He submitted that he is basically appointed as constable and finally promoted as head constable. He always served the department with due honesty and satisfaction. He never violated any provision of law, but with certain ulterior motive, a false FIR has been registered against him, in consequence of which he has been charge sheeted, and department, without hearing him, has passed the order of premature retirement, which is illegal, perverse, and liable to be set aside and quashed. He submitted that the finding or order of premature retirement based on the criminal case means vigilance case is nothing but abuse of process, because the allegations in the criminal case are not proved. So if the allegations are not proved, then on similar facts, the departmental action would be nothing but abuse of process. It is submitted by the accused, means by the charge official, that the department acted in the arbitrary way. As we know that before passing any order that is adverse, the opportunity of being heard is to be given to the opposite party, but the said opportunity is not given in the present case. First of all, we have to see the content of the report, and apart from that, we have to check the quality of the allegations. If the allegations are not having the specific quality, they are zigzag. Apart from that, allegations are omnibus, non-specific, we could get the benefit. In addition to this, it is submitted that the order of premature retirement is against the settled norms, because the order could not be passed if the allegations are not proved. The factum of acquittal in the criminal case has been informed to department by the accused, but despite of that, the scenario has not been taken into consideration. It is emphasized by the concerned accused. He submitted that he is in service with department since a long time, and in the entire period, there is no allegation against him regarding the misconduct, and that's why proceeding at present is nothing but abuse of process. In addition to this, he submitted that the departmental action is based on the criminal case. The criminal case allegation is found to be unproven. In that scenario, accused submitted that he deserves the benefit of acquittal, and the departmental action is liable to be dropped, set aside, and closed. The concerned respondent submitted that, as per the protocol, the notice is not required to be given, and apart from that, the allegations are serious in nature. In the present case at hand, the authority observed that the present proceedings in nature of departmental action are based on the criminal case. In criminal case, the accused is found not guilty. The concerned authority is totally duty bound to hear you while passing any impugn order. If the opportunity of being heard is not given, you may challenge the proceeding, even though the department says that you are having multiple cases. Apart from that, allegations are serious, and that's why there is no need to give show cause notice. Such approach is fatal. So basically, if the criminal case is resulted into the acquittal and on same facts departmental action is initiated, in that scenario, the departmental action is liable to be closed. So if department is not going to give you the benefit in that scenario, you must submit your objections in light of judgment which I specified to you. And in case they fail to consider your submission and inter alia initiated the proceeding, you may challenge the consent order before CAT or before Honorable High Court. But if the remedy lie before CAT, the writ petition would not lie before Honorable High Court. So I think that I enlightened you on the important subject. See you in the next video. Till then, Jai Hind, Jai Bharat.